Hi, I'm Chad McCoy.
And I'm Sheila Heaston. We're with the law firm of McCoy and Heaston with offices in Bardstown and Louisville, Kentucky. We practice a lot of medical negligence claims, and there has been a new law passed in the legislature this session, KRS Chapter 216C, that has to deal with medical panels. Chad's going to tell you a little bit more about it.
So the new law is designed to add a review process to any complaint that you're going to file before you can go to court. The idea behind the law was that we would have 3 independent experts look over the case to determine whether or not the case is a valid case, that if it has merit. Then these independent experts will give an opinion as to whether or not they think there's either been a breach of the standard of care or there hasn't been a breach of the standard of care, and if there has, whether or not it caused any damage. And the way the law works now is rather than filing your case in actual court, you will first file with the Cabinet for Health and Family Services here in Kentucky. Pay a filing fee, and then what that's going to do is stop the lawsuit statute of limitations until you have an opinion from the panel. And the law actually says you're not allowed to file in court until you either get a panel opinion or 9 months goes by. So there still is some way to get back in front of the judge if the panel hasn't reached a decision in 9 months. Hopefully then what the panel will do is review the medical records, maybe even take some depositions and testimony, and look at the case to try to decide whether or not it has merit. Regardless, other states have this already. Indiana, which is real close to us, has it. And really all this panel is going to do is give us something to work with, but it's unfortunately going to add a huge delay to your claim. And in addition to the 9-month wait, if the panel hasn't made a decision, there is some concern that maybe the courts will wait on the panel. But regardless of what the panel does, you will still end up, especially if we're your attorneys, probably going ahead with a lawsuit as well. We're not going to rely on their experts. We need our own experts to look at it, especially because they're not going to have all the information when they make their decision.
I obviously have some concerns with this law. 75% of my practice is medical negligence. So the fact that this creates a 9-month delay before I can get to the courthouse, I find that unfortunate for my clients and for the cost associated with the case, because I think there's going to be some duplication of effort in terms of discovery, depositions. I don't think you can do anything in a meaningful process from putting on your case in front of a panel given the time deadlines that are set forth. And I think that the delay is only going to hurt a lot of our clients who are so sick that they're dying and will die before the 9-month process has ended. I think that there will be problems with, again, the cost of duplicating effort. And but what we are here to do today is work within the bounds of the law. It is the law, so we will find a way to make it work. We will walk you through the process, and we will make sure that you get excellent representation throughout all aspects of the case. One of the interesting aspects of this law is that it's not just when you're suing a doctor or you're suing a hospital. What it includes is hospital, psychiatric hospitals, physical rehabilitation, PT, chemical dependency programs, tuberculosis hospitals, skilled nursing facilities, immediate care facilities, so the Walgreens immediate care facility, family care homes, ambulatory care centers, ambulance providers, hospice, community centers for mental health, home health, assisted living communities, and here's the interesting part: dietitians, nutritionists, medical imaging technologists, chiropractors, dentists, dental hygienists, dental labs, respiratory therapists, pharmacists, pharmacy psychologists, occupational therapists, medical laboratories, optometrists, social workers, licensed marriage family therapists, licensed preventive clinical counselors, and licensed pastoral counselors. So it's all pretty all-encompassing. So anytime you get any kind of substandard care, we're going to have to look at the law and see if this applies to you. And I would say that probably, yeah, it does.
That's right.